The Senate is back in order. We are on the second agenda of the day. Order of business 4, reports of committees.
We have no reports at this time.
Order of business 6, messages from the Assembly.
Assembly Chamber, Carson City, May 26, 2023. To the Honorable Senate, I have the honor to inform your honorable body that the Assembly on this day passed Senate bills numbers 251 and 429. Also, I have the honor to inform your honorable body that the Assembly amended and on this day passed as amended Senate Bill number 57, Amendment 719, Senate Bill 60, Amendment 721, Senate Bill 80, Amendment 604, Senate Bill 332, Amendment 659, Senate Bill 384, Amendment 593, Senate Bill 418, Amendment 699, Senate Bill 436, Amendment 710, and respectfully request your honorable body to concur in said amendment. Signed, Carol Ayala Sala, Assistant Chief Clerk of the Assembly. End of messages.
Order of business 8, waivers and exemptions.
A waiver requested by Senator Cannizzaro for SB 507 to waive subsections 1 of 14.2 and subsections 1, 2, 3, and 4 of Senate Rule 14.3 has been granted effective March 27th, 2023. Signed, Senator Nicole Cannizzaro and Assemblyman Steve Yeager. End of waivers.
Order of business 9, motions, resolutions, and notices. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Bills numbers 86, 284, 285, and 339 be taken from their positions on general file and placed on the Secretary's desk.
All those in favor signify by saying aye. Opposed, nay. Motion carries. Senator Cannizzaro.
Thank you, Mr. President. I move that Assembly Bills numbers 17, 32, and 51 be taken from the Secretary's desk and placed on general file.
Heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries.
Senate Resolution 7, just introduced by Legislative Operations and Elections, designates certain members of the Senate as regular and alternate members of the Legislative Commission for the 2023-2025 biennium. End of resolution.
Are there any amendments?
There are none.
Senator Orenshaw.
Thank you, Mr. President. I move for the adoption of Senate Resolution 7.
You've heard the motion. Senator Orenshaw.
Thank you, Mr. President. As the Secretary mentioned, Senate Resolution 7 designates the Senate members and Senate alternate members for the Legislative Commission for the upcoming biennium.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. SR 7 is order transmitted to the Assembly.
Assembly Joint Resolution 1, introduced by Assemblyman MacArthur, et cetera, and Senator Krasner, et cetera, urges the United States Department of Veterans Affairs to study the effectiveness and use of hyperbaric oxygen therapy for veterans. End of resolution.
Are there any amendments?
There are none.
Senator Orenshaw. Senator Krasner.
Thank you, Mr. President. Assembly Joint Resolution 1 urges the United States Department of Veterans Affairs to study the effectiveness and the use of hyperbaric oxygen therapy for veterans and share the results with the state of Nevada.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AJR 1 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Joint Resolution 5, introduced by Assemblyman C.H. Miller and Monroe Moreno, proposes to amend the Nevada Constitution to revise provisions relating to lotteries and the sale of lottery tickets. End of resolution.
Are there any amendments?
There are none.
Senator Daly.
Thank you, Mr. President. Assembly Resolution 5, Joint Resolution 5, proposes to amend the Nevada Constitution to authorize the legislature to provide by law for the operation and regulation of lotteries, including without limitation the sale of lottery tickets. The resolution prohibits the legislature from passing any laws which grant a special charter or similar governing document to any person or entity to operate a lottery or sell lottery tickets, and further prohibits political subdivisions of the state from operating a lottery or selling lottery tickets. Additionally, the resolution clarifies that the operation of any charitable lotteries must comply with the existing provisions in the Nevada Constitution governing charitable lotteries. Thank you.
Are there any remarks from the floor? Senator Sears-Gansert.
Thank you, Mr. President. I rise in opposition to AGR 5. It's been well known and researched that lottery tickets are sold to people who are of lower income, and it's a regressive, not necessarily tax, but it's a regressive way for people to spend money when they could be spending it on the things like foods. And we also have an industry here that employs thousands and thousands of individuals who've invested in bricks and mortar in our state, and this would undermine what is the largest economic driver in our state. Thank you.
Senator Pizzina.
Thank you, Mr. President. While I rise in tentative support of AJR 5, I do have a number of concerns that I look forward to addressing with the bill sponsor and those during the interim session. Thank you.
Any other remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 12, the noes are 8. AJR 5 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Joint Resolution 1 of the 81st session, introduced by Assemblywoman Titus, et cetera, and Senator Hardy, et cetera, proposes to amend the Nevada Constitution to add and revise terms relating to persons with certain conditions for whose benefit certain public entities are supported by the state. End of resolution.
Are there any amendments?
There are none.
Senator Titus.
Thank you, Mr. President. Assembly Joint Resolution 1 of the 81st session proposes to amend Section 1 of Article 13 of the Nevada Constitution by replacing the description of persons who benefit from institutions fostered and supported by the state from 1, insane, to persons with significant mental illness, and 2, blind, to persons who are blind or visually impaired, and 3, deaf and dumb, to persons who are deaf or hard of hearing. The resolution also replaces the term institutions with entities and adds entities for the benefit of persons with intellectual or developmental disabilities to the types of entities that shall be fostered and supported by the state. This resolution was approved by the 81st session of the legislature in 2021 by both houses by full support. If approved in identical form during the 2023 legislative session, the proposal will be submitted to the voters for final approval or disapproval of the 2024 general election. I appreciate all of you hearing me present this bill time and time again, 4 separate occasions, twice in each house, and so I appreciate all of your support and look forward to you supporting it one more time. Thank you.
Are there any remarks from the floor? Senator Sears-Gansert.
I rise in support of HR 1, and I also want to compliment the senator from District 17 for her perseverance. She's been working on this for quite a while, and I'm glad we're here today. Thank you.
Any further remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AJR 1 has received a constitutional majority to declare passed and ordered to the Assembly.
Assembly Concurrent Resolution 5, introduced by the Assembly Committee on Legislative Operations and Elections, expresses support for the Lake Tahoe Transportation Action Plan. End of resolution.
Are there any amendments?
There are none.
Senator Scheibel.
Thank you, Mr. President. Assembly Concurrent Resolution 5 expresses the legislature's support for the Lake Tahoe Transportation Action Plan and for the funding of high-priority transportation projects in the Lake Tahoe Basin.
Are there any remarks from the floor? Senator Titus.
Thank you, Mr. President. Unfortunately, I have to rise in opposition of ACR 5. I have had many of the individuals who live at Lake Tahoe express significant concerns on the Transportation Action Plan. And I will be meeting with them, actually just starting next, after as soon as session is over, to address some of those concerns. And until I can have a full understanding of the impact on my constituents, I will have to be a no. Thank you.
Any further remarks on the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. The motion is carried. Resolution ACR 5 is ordered transmitted to the Assembly.
Point of order.
Yeah, what do you,
That's
Senator Severs Ganser, what did you want to do here?
We want a roll call vote on ACR 5. Thanks.
Point of order, according to the
Senator Severs Ganser, Senator Cannizzaro.
Thank you, Mr. President. According to the Senate's standing rules and rules of parliamentary procedure, a point of order must be made at the time that the vote is taken, not after it has already been determined by the presiding officer that the motion was sustained and ordered to the Assembly. So I believe that that motion for a roll call vote would have had to have been made at the time of the vote, not now, and is now out of order.
Okay, that is correct. So we will.
Whoa. Point of order. We
Senator
haven't gone
Hanson.
to the next thing. That was in a completely reasonable period of time. I appeal to the parliamentarian that the minority leader did that in a completely appropriate time frame. While it was maybe been a 10 or 15 second delay, it was certainly well within the time that is allotted, since we have not moved on to the next agenda item. So I'd like to appeal to the parliamentarian to sustain the attempt to have a roll call vote. Thank you, Mr. President.
What?
I'm going to take a recess so we can look at this.
Do it. You can do it right now.
Okay, the Senate is back in order. So as far as ACR 5,
Point of order, Mr. President.
Senator Canizaro.
My colleague from Senate District 14 stated point of order, but really made a motion for an appeal. There was no explanation of what the point of order was, a rule or otherwise. It was an appeal of the previous point of order. However, an appeal under the Senate standing rules must be sustained by 2 standing senators, and there were no standing senators, so I believe that the appeal is out of order.
Okay, well, my ruling is going to be that we heard we motioned, we voted on it. I said that the motion carried, resolution is adopted, is ordered to the Assembly. That was the end of that particular item. We're ready to move on to the next one. At that point, there was basically a request to have a division of the House, and I don't believe that we could have done that at that particular point. So if you would like to appeal my ruling, we can put it to a vote. Does anybody want to request that vote? Okay, then that will be my ruling, and we are done with ACR 5.
That concludes Order Business 9.
Order of Business 10, introduction, first reading, and reference.
Senate Bill 506, introduced by Finance, revises provisions relating to records of criminal history, and a bill.
Senator Nandero Loop.
Sorry, sir, I didn't have anything. I move to refer, thank you, Mr. President. I move to refer Senate Bill 506 to Finance.
You've heard the referral. If there are no objections, so ordered.
Senate Bill 507, introduced by Senator Canizaro, revises provisions relating to the Hearings Division of the Department of Administration, and a bill.
Senator Nandero Loop. Senator Canizaro.
Thank you, Mr. President. I would move to refer Senate Bill number 507 to the Committee on Government Affairs.
If there are no objections, so ordered.
Senate Bill 508, introduced by Finance, makes an appropriation to the Office of Finance and the Office of the Governor for the Nevada Educational Choice Scholarship Program, and a bill.
Senator Nandero Loop.
Thank you, Mr. President. I move to refer Senate Bill 508 to Finance.
You've heard the referral. If there are no objections, so ordered.
Senate Bill 509, introduced by Finance, revises provisions governing stadium infrastructure projects, and a bill.
Senator Nandero Loop.
Thank you very much, Mr. President. I move to refer Senate Bill 509 to Finance.
If there are no objections, so ordered.
That concludes Order Business 10.
Order of Business 13, General File.
Senate Bill 274, introduced by Senator Daley, revises provisions relating to industrial insurance. People of the State of Nevada, represented in Senate Assembly, to enact as follows, Section 1 and to Section 1.
Are there any amendments?
I have amendment number 736, proposed by the Senate Committee on Finance.
Senator Nandero Loop.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Nandero Loop.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion. Senator Nandero Loop.
Thank you, Mr. President. Senate Amendment number 736 to Senate Bill 274 revises the timeframes in Section 4 for an aggrieved person to appeal the administrator's failure to respond to a complaint alleging certain violations by an insurer, managed care organization, healthcare provider, third-party administrator, employer, or professional employer organization.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. We will now Let's see, this is SB 274 is ready for final action.
Senate Bill 274, introduced by Senator Daley, revises provisions relating to industrial insurance. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 6, end of Section 6, end of bill.
Senator Daley.
Thank you, Mr. President. Senate Bill 274, as amended, requires the administrator of the Division of Industrial Relations of the Department of Business and Industry to post certain information on the division's website, increase the penalties for certain violations of the Nevada Industrial Insurance Act or the Nevada Occupational Disease Act, revises provisions related to benefit penalties, modifies investigation requirements conducted by the administrator, and addresses other related matters, including the time frame by which an administrator is required to respond to certain written requests. Senate Bill 274, as amended, becomes effective on passage and approval for the purpose of adopting any regulations and performing any other preparatory administrative tasks, and on January 1, 2024, for all other purposes.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 14. The noes are 6. SB 274 has received a constitutional majority, is declared passed and ordered to the Assembly.
Senate Bill 387, introduced by Senator Pizzina, revises provisions related to the state personnel system. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. End of bill.
Senator Titus.
Thank you, Mr. President. Senate Bill 387 requires the Administrator of the Division of Human Resources Management of the Department of Administration to periodically review the positions in the classified service of the state that require a person to hold a bachelor's degree and revise qualifications to allow a person to substitute experience or skills in lieu of a bachelor's degree if the administrator deems it is necessary for the efficiency of the public service. SB 387 becomes effective October 1st, 2023. Mr. President, it's my personal opinion that this is probably one of the most important pieces of legislation we will pass this session for filling our vacancies in our state. And I want to commend the author, which is our Senator Pizzina, for bringing this forward. I think it will go a long way to fill positions with skilled laborers and skilled workers for our state. So I urge the passage of this bill. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll.
Sorry.
Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. SB 387 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 17, introduced by the Assembly Committee on Judiciary, revises provisions relating to penalties for driving under the influence of alcohol or a controlled substance. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective upon passage and approval. End of bill.
Senator Harris.
Thank you, Mr. President. Assembly Bill 17 removes the requirement that a person who's convicted of driving under the influence of alcohol or a controlled substance must dress in certain distinctive garb while performing community service ordered by a court. Bill is effective upon passage and approval.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Secretary will close the roll. The yeses are 18, the noes are 2. AB 17 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 32, introduced by the Assembly Committee on Judiciary, makes various changes relating to criminal justice. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
I have amendment number 765, proposed by Senator Scheibel.
Senator Scheibel.
Thank you, Mr. President. I move to dispense with the reading of Amendment 762.
If there are no objections, so ordered. Senator Scheibel.
I move to adopt Amendment 765 to Assembly Bill 32.
You've heard the motion, Senator Scheibel.
Amendment 762 adds courts to the list of entities that the Nevada Local Justice Reinvestment Coordinating Council is to include in its consideration for recommendations to the Sentencing Commission regarding grants to local governments.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. SB 32 is ready for final action.
Assembly Bill 32, introduced by the Assembly Committee on Judiciary, makes various changes relating to criminal justice. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. Section 10, this act becomes effective on July 1, 2023. End of bill.
Senator Scheibe.
Thank you, Mr. President. Assembly Bill 32 revises certain provisions governing the Department of Sentencing policy, including changing the requirements to serve as executive director, specifying that any information collected or stored by the department for the purpose of analyzing and understanding the criminal justice system is confidential, not a public record, and requiring the collection and reporting on certain data relating to the length of imprisonment, recidivism rates for persons who are on probation, the suspension of their sentence, and parole and supervision. The bill also revises certain provisions regarding the Nevada Sentencing Commission, and further, it authorizes the Nevada Local Justice Reinvestment Coordinating Council to accept gifts, donations, bequests, grants, or other sources of money to carry out its duties. This bill also makes provisions relating to the Division of Parole and Probation and the Department of Public Safety, and includes revising the risk and needs assessment administered to certain probationers and parolees, authorizing the division to impose confinement in jail or detention facility or place a person under a system of active electronic monitoring for technical violations of probation or parole, and requiring a system of graduated sanctions to include the use of such confinement. The bill also authorizes the State Board of Parole Commissioners to revoke probation or parole, suspension of the sentence, or parole supervision at the request of a probationer or parolee, and a probationer who is arrested or detained or whose parole is revoked for committing a technical violation must receive credit for any time served while awaiting a hearing. The bill increases the term of imprisonment for a temporary revocation of parole supervision from 30 days to 90 days for the first temporary revocation, and from 90 to 180 days for the second temporary revocation. Finally, full revocation of parole supervision is authorized for a third or subsequent revocation.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 32 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 33, introduced by the Assembly Committee on Government Affairs, revises provisions governing public investments. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 5, this act becomes effective on July 1, 2023. End of bill.
Senator Bocaccia.
Thank you, Mr. President. Assembly Bill 33 expands the authorized investments for money in the State Permanent School Fund upon the state treasurers obtaining a judicial determination that such an investment does not violate the Nevada Constitution. The measure revises provisions governing money transferred from the fund to a corporation for public benefit to provide private equity funding to certain businesses. The measure revises the authority of the state engineer to invest money from the general portfolio of the state in certain categories of bonds and other securities. Finally, the measure revises the provisions relating to the authorized investments for a local government and certain administrative entities. Effective date 2023. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Does anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 19, the noes are 1. SB 33 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 51, introduced by the Assembly Committee on Judiciary, makes various changes relating to public safety. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 21 into Section 21. End of bill.
Senator Dondero Loop.
Thank you, Mr. President. Assembly Bill 51 revises the period for a mandatory and discretionary arrest of a person suspected of committing a battery which constitutes domestic violence. The bill requires a peace officer to arrest a person suspected of such a crime within 24 hours after the alleged battery if the peace officer had a face-to-face encounter with the person while responding to the initial request for assistance relating to the battery, or within 7 days after the alleged battery if the peace officer did not have a face-to-face encounter with the person while responding to the initial request. The bill also prohibits a court from granting probation to or suspending the sentence of a person who is charged with committing a battery which constitutes domestic violence that is punishable as a felony. Finally, a person who has received appropriate training and who works for a domestic violence, sexual assault, or human trafficking services organization or a nonprofit organization that provides assistance to victims may be deemed a victim's advocate for the purposes of privileged communications between a victim and such an advocate. This bill is effective October 1st, 2023.
Are there any remarks on the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 51 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 55, introduced by the Assembly Committee on Judiciary, revises provisions related to unclaimed property. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. Section 17, this act becomes effective on July 1, 2023. End of bill.
Senator Scheibel.
Thank you, Mr. President. Assembly Bill 55 revises various provisions of the Uniform Unclaimed Property Act, including but not limited to making various changes relating to the dates on which certain unclaimed property is presumed abandoned, requiring the administrator of unclaimed property to create and maintain a statewide publicly available searchable database that includes the name of the person reported to be the apparent owner of the unclaimed property, removing the requirement that the administrator must provide written consent before the abandoned property is delivered to the apparent owner if the receipt of the property is in the best interest of the state, and revising the notice that the administrator must make to sell certain abandoned property at public sale. The bill also authorizes the administrator to request a state or local agency to provide certain confidential information for the purpose of facilitating the return of unclaimed or abandoned property and to adopt regulations relating to agreements which assist a property owner in the return of property that is presumed abandoned. Finally, the bill repeals provisions requiring that the act must be applied and construed to effectuate its general purpose to make the law uniform among the states that enact the act.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 55 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 74, introduced by the Assembly Committee on Education, revises provisions relating to agreements entered into by public bodies. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
Amendment number 746, proposed by Senator Daley.
Senator Daley.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
There are no objections, so ordered. Senator Daley.
Thank you, Mr. President. I move that the Senate adopt Amendment 746 to Assembly Bill 74.
You've heard the motion. Senator Daley.
Amendment 746 removes franchise, easement, permit, and right of entry from the definition of concession as provided in Section 2.3 of the bill, and removes maintenance yards and buildings, control systems, communication systems, information systems, and energy systems, and the improvements outlined in subsection B from the definition of facility as provided in subsection 2.4 of the bill.
Are there any remarks from the floor? Seeing none, those in favor signify by saying aye. Opposed, nay. Motion carries. AB 74 is ready for final action.
Assembly Bill 74, introduced by the Assembly Committee on Education, revises provisions relating to agreements entered into by public bodies. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. Section 3, this act becomes effective on July 1, 2023. End of bill.
Senator Daley.
Thank you, Mr. President. Assembly Bill 74 authorizes the Board of Regents of the University of Nevada to enter into agreements with a public or private entity to promote and enhance an educational program or student life at an institution and outlines certain provisions of such agreements, including certain requirements relating to prevailing wage. The bill further determines that any such agreement is subject to certain policies established by the board. Finally, AB 74 authorizes a public body to enter into a public-private partnership to plan, finance, design, construct, improve, maintain, operate, or acquire certain facilities. Bill becomes effective July 1, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 13, the noes are 7. AB 74 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 75, introduced by Assemblyman Yeager, revises certain requirements relating to securities. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 and Section 1.
Are there any amendments?
There are none. Section 6 and Section 6 and a bill.
Senator Wynn.
Sorry, my bad. Assembly Bill 75 authorizes the adoption of regulations to establish requirements for transactions involving an offer or to sell or sale of a security to a Nevada certified investor. A Nevada certified investor is a natural person who is or is a married couple who are a resident of the state and who at the time of the offer to sell or sale of a security is made to a person or a couple meets certain financial qualifications. The administrator may adopt regulations as set forth additional requirements that must be met for a transaction to qualify for an exemption from paying any fees associated with registration filing requirements.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 75 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 91, introduced by Assemblyman DeLong, revises provisions governing water. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows, Section 1 and Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective on July 1, 2023, and a bill.
Senator Flores.
Thank you, Mr. President. Assembly Bill 91 allows a person to sink or bore a replacement well without submitting application to change the place of diversion of water already appropriated if both the original well and replacement well are on public lands and the replacement well is within 300 feet of the original place of diversion. Finally, a person seeking to sink or bore a replacement well on public lands must notify any relevant federal agency that is charged with administering such public lands and comply with all applicable federal laws.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Senator Scheibel and Dondero Loop. Anyone who wishes to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 91 has received the constitutional majority, is declared passed and ordered to the Assembly. The following bills are ready to be immediately transmitted to the Assembly. Senate Bills 274, 387. Once these bills have been transmitted to the Assembly, the Senate no longer has the ability to take any further action. Any remarks or objections? Seeing none, we'll continue.
Assembly Bill 97, introduced by Assemblywoman Hardy, revises provisions relating to government administration. The people of the state of Nevada, represented in Senate Assembly, do enact as follows, Section 1 and Section 1.
Are there any amendments?
There are none. Section 8, this act becomes effective upon passage and approval, and a bill.
Senator Orenshaw.
Thank you, Mr. President. Assembly Bill 97 precludes certain government entities from adopting a building code or taking any other action prohibiting or limiting the use of refrigerants designated by the United States Environmental Protection Agency as a refrigerant alternative or substitute if equipment installation complies with certain industry standards. The bill authorizes the governing body of any city or county or any other governmental entity to adopt a building code or ordinance or take any other action to prohibit the construction or use of evaporative cooling mechanisms or restrict water service to properties using these mechanisms. Finally, the bill voids any currently existing building codes or other actions adopted by the governing body of a city or county or any other governmental entity limiting or prohibiting refrigerant alternatives or substitutes. And Mr. President, when I first heard about this bill coming over from the other side about refrigerants, I was worried it would get a chilly reception, but it seems like the hardworking Committee on Government Affairs really liked it. Hopefully, this chamber will like it too.
Are there any remarks on the floor? Seeing none, the Secretary will open the roll. Senator Harris. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 97 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 107, introduced by the Assembly Committee on Commerce and Labor, revises provisions governing certain pharmacies located outside the state. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 9, end of Section 9, end of bill.
Senator Pazina.
Thank you, Mr. President. Assembly Bill 107 requires a pharmacist who is employed by an off-site pharmaceutical service provider to provide remote chart order processing services to a hospital or correctional institution in this state to be registered to practice in Nevada. The measure requires a pharmacy located outside of this state that dispenses prescriptions to patients in Nevada as part of its application for the issuance or renewal of a license to provide to the State Board of Pharmacy the name of at least one pharmacist registered in this state who practices at the pharmacy and who is responsible for any prescription dispensed to a patient and any act or omission of pharmacy personnel who are not registered with the board. This bill is effective October 1, 2023.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 107 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 120, introduced by Assemblyman Hafen, revises certain provisions governing voluntary health care service. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. End of bill.
Senator Spearman.
Thank you, Mr. President. Assembly Bill 120 prohibits a provider of health care who was not initially issued his or her professional license or certificate within the immediately preceding 3 years and who has not practiced his or her profession within the immediately preceding 3 years from providing voluntary health care services in the state. The bill is effective on October 1, 2023.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Senator Buck. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 120 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 124, introduced by Assemblywoman Hardy, revises provisions governing the renewal of a license as an osteopathic physician or physician assistant. The people of the state of Nevada, represented in Senate and Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective upon passage and approval. End of bill.
Senator Buck.
Thank you, Mr. President. Assembly Bill 124 removes the requirement the State Board of Osteopathic Medicine annually requests submission of verified evidence of the completion of the required number of continuing medical education hours from not fewer than 1/3 of the applicants for a license renewal. Instead, the measure requires the board to annually request the submission of such evidence from a percentage of applicants determined by the board. This bill is effective upon passage and approval.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Senator Daley. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 124 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 143, introduced by Assemblyman O'Neill, revises provisions governing counties. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 6, this act becomes effective on October 1, 2023 and expires by limitation on June 30, 2025. End of bill.
Senator Krasner.
Thank you, Mr. President. Assembly Bill 143 authorizes a Board of County Commissioners of a county whose population is less than 4,500 to convey without consideration and without complying with certain requirements in existing law real property that the county acquired directly from the federal government for the purpose of clearing title to the property. The real property must be conveyed as prescribed to the person or persons as applicable who have an interest in the property. The measure exempts such a conveyance from the provisions that generally apply to the sale or lease of property by a board of county commissioners and the real property transfer tax.
Are there any remarks on the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 143 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 159, introduced by Assemblyman O'Neill, etc., revises provisions relating to cruelty of animals. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 6, this act becomes effective upon passage and approval. End of bill.
Senator Krasner.
Thank you, Mr. President. Assembly Bill 159 adds certain offenses relating to cruelty to animals to the list of offenses for which 1. Credits earned by offenders may not be deducted from the minimum term or the minimum aggregate term imposed by a sentence. 2. The court may not defer judgment. And 3. A person must not have been convicted to be eligible for early discharge from probation. Lastly, the bill sets the maximum period of probation or suspension of sentence for these offenses at 60 months.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Senator Harris, Senator. Okay. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 159 has received a constitutional majority. It is declared passed and ordered to the Assembly.
Assembly Bill 175, introduced by Assemblyman York and Bilberg Axelrod, revises provisions governing boards of trustees of school districts. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 9, this act becomes effective on July 1, 2023. End of bill.
Senator.
Mr. President, may we go to order business number 9?
Okay, we are on order of business 9.
Thank you, Mr. President. I would move to take Assembly Bills 175 and 188 and place them at the end of general file for this agenda.
Okay, if there are no objections, so ordered. We are now back on order of business 13, general file.
Assembly Bill 177, introduced by Assemblyman Gurr, etc., revises provisions governing parcel data sets. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. End of bill.
Senator Gokachia.
Thank you, Mr. President. Assembly Bill 177 adds an association for operators, which is an organization which receives certain notifications for transmittal to its members who own, operate, or maintain a subsurface installation to the list of entities that the state demographer of the Department of Taxation must, upon request, provide the fiscal year-end parcel database of a county. The measure adds, without limitation, Underground Service Alert of Northern California and Nevada, or its successor organization, to the definition of an association for operators for purposes relating to this provision, effective October 1st, 2023, USA dig kind of thing. Get clearance before you dig.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 177 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 183, introduced by the Assembly Committee on Judiciary, revises provisions relating to the protection of children from commercial sexual exploitation. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 7 into Section 7. End of bill.
Senator Dondero Loop.
Thank you, Mr. President. Assembly Bill 183 requires a local facility for the detention of children, a regional facility for the treatment and rehabilitation of children, and a state facility for the detention of children to screen each child with certain exceptions to determine whether the child is a victim of commercial sexual exploitation. Facilities must report commercial sexual exploitation of a child to an agency that provides child welfare services if the results of the screening indicate the child is victim. The reporting is deemed to be a report for purposes of certain mandatory requirements and procedures for reporting abuse, neglect, or exploitation of a child. This bill requires such a child welfare agency to take certain actions to protect the safety of the child and meet the child's other needs upon receipt of the report. Lastly, an agency that provides child welfare services must conduct a similar screening for each child in its custody with certain exceptions. This bill is effective upon passage and approval for purposes of adopting regulations on or before administrative tax and on October 1st, 2023 for all other purposes. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 183 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 191, introduced by Assemblyman DeLong, etc., revises provisions relating to water conservation. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. End of bill.
Senator Hansen.
Thank you, Mr. President. Assembly Bill 191 excludes from the term supplier of water a public or private entity with less than 15 service connections, thereby removing the requirement for such an entity to adopt and update a plan of water conservation, conduct a water loss audit, or adopt a plan to provide certain incentives relating to water conservation. The effective date will be October 1st, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 191 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 220, introduced by the Assembly Committee on Natural Resources, revises provisions relating to water conservation. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
I have amendment number 735, proposed by Senator Wynne.
Senator Wynne.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Wynne.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion. Senator Wynne.
Amendment 735 to Assembly Bill 220 does the following. It authorizes the Board of Directors of the Southern Nevada Water Authority to restrict the use of water by a single-family residence to not more than 0.5 acre-feet of water during any year in which the federal government reduces Nevada's allocation of the Colorado River to 270,000 acre-feet or less. That would mean that the federal government would have to reduce the state of Nevada's water allocation by 10%, which equates to about a 30-foot drop at Lake Mead.
Are there any remarks on the floor? Seeing none, those in favor signify by saying aye. Opposed, nay. Motion carries. AB 220 is now ready for final action.
Assembly Bill 220, introduced by the Assembly Committee on Natural Resources, revises provisions relating to water conservation. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 36, this act becomes effective upon passage and approval. End of bill.
Senator Pazina.
Thank you, Mr. President. Assembly Bill 220 revises provisions related to water conservation. The bill authorizes a district board of health to establish a voluntary program to pay the cost for property owners with a septic system whose property is served by a municipal water system to connect to the community sewage system. The bill also authorizes a district board of health, upon an affirmative vote of 2/3 of the members of the board, to impose a voluntary annual fee capped at the annual sewer rate of the largest community sewer system in the county to carry out such requirements. Additionally, AB 220 revises the Conservation of Colorado River Water Act to, amongst Other things prohibit the installation or irrigation of non-functional turf on certain parcels and restrict the use from the Colorado River in certain circumstances. The Board of Directors of the Southern Nevada Water Authority must establish a process to approve a waiver of such water restrictions for certain properties. Finally, among other provisions, AB 220 revises certain responsibilities that local governing bodies and certain other entities must agree to or undertake before a permit to operate a water system can be issued, requires suppliers of water to review and comment on a tentative map and approve a final map regarding the availability of water for proposed subdivisions in certain counties, revises provisions relating to the issuance and revocation of temporary permits to appropriate groundwater, and requires, with certain exceptions, the new construction, expansions, and renovations of certain structures include the installation of certain irrigation controllers and spray sprinklers. And I would like to thank Senator Wynn for her extensive work on this, inclusive of making this a voluntary program and covering up to 100% of fees for the transition. Thank you.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 17, the noes are 3. AB 220 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 250, introduced by Assemblywoman Considine and Anderson, establishes provisions governing prescription drugs to people of the state of Nevada, represented in Senate Assembly, to enact as follows: Section 1 into Section 1.
Are there any amendments?
There are none. Section 5 into Section 5 into bill.
Senator Scheibel.
Thank you, Mr. President. Assembly Bill 250 prohibits a person or entity during the price applicability period that 1, purchases a drug that is subject to a maximum fair price in the state from paying a price that is higher than the maximum fair price, or 2, seeks reimbursement for a drug subject to a maximum fair price that is delivered, dispensed, or administered to a person in the state from seeking reimbursement at a higher rate than the maximum fair price. This bill makes it a deceptive trade practice for any person to violate the prohibition on purchasing or seeking reimbursement for a drug price higher than the maximum fair price. A victim of such a violation may bring a civil action.
Are there any remarks from the floor? Senator Stone.
Thank you. Good evening, Mr. President and colleagues. I'm sure your office, as well as my office, has received a lot of calls about AB 250. This bill was drafted in response to the provisions of the dubiously labeled Inflation Reduction Act that requires the U.S. Secretary of Human Services to negotiate the prices of drugs in Medicare Parts B and D with the highest Medicare spending. It further requires drug companies to pay rebates to Medicare if drug prices exceed inflation for Medicare beneficiaries. The act will require the Secretary of Health and Human Services to negotiate prices with drug companies making a handful of drugs that are single source, meaning there are no generics, or biologics, which means they have no substitutes, hopefully making them less expensive. The federal bill originally included not just Medicare, but also all private insurers, but they were amended out of the bill. Hence, this federal law only applies to Medicare. Let me repeat this. This federal law only applies to the federal entitlement program, Medicare. The number of drugs for the first year will be 10 drugs, which I'm going to refer to as the top 10, beginning in 2026, another 15 in 2027, and in 28, and 20 drugs in 2029 and beyond. This is a federal law in conformance with the federal government's exclusive jurisdiction over U.S. Food and Drug Administration and the U.S. Health and Human Services effectuating U.S. drug policies. The true beneficiary of this complicated piece of legislation is Medicare, which stands to potentially save on their expenditure of money on drugs for Medicare populations only. The U.S. government and drug companies will take into consideration in their negotiations drug patent links, years that the drugs have been on the market, etc. The good news is that the U.S. taxpayers can be the true beneficiaries if negotiations are indeed fruitful. The bad news is if a drug company does not want to play ball with the feds, they can just withdraw their drugs from Medicare altogether, leaving 100% of the cost of these drugs on the patients that otherwise could have had them covered on Medicare. That brings me to AB 250, and believe me, if we could just pass a law like this that would require drug companies to honor such Medicare discounts to private insurers with the caveat that the insurance companies extend those savings to the patient, why wouldn't we just do that? But here are some troubling issues with this bill. AB 250 is isolating and mandating that a pharmacy sell such drugs at the Medicare discounted price if successfully negotiated by the feds with the drug companies. While this may help the few patients paying cash for their prescriptions, this will primarily benefit insurers that by virtue of this bill have no mandate to pass such savings on to patients via reduced copays. Let me say it again. There is no provision in this bill that the savings be passed on to the patient unless they are cash payers, of which there are only a handful. While this legislation targets pharmacies, they do not have any legal right to demand discounts from drug manufacturers, nor do drug wholesalers have any right to demand discounts from drug manufacturers. Can drug wholesalers ask for discounts? Yes, but nothing compels a drug company to honor such requests. The problem is that pharmacies buy primarily from wholesalers, and the wholesalers are not given the same Medicare discounted prices. So for a pharmacist to comply with this potential new state law, if it were to become enacted and signed, the pharmacy would have to sell the drug to either the patient or the insurance company covering the patient at a loss, or not fill the prescription, which is their legal right. If I own the pharmacy and I've got to sell it for hundreds of dollars less than I paid for it, I'm going to tell the patient, I'm sorry, but I can't fill this prescription. The most egregious part of this bill is that if the pharmacist does not sell the prescription drug at the discounted Medicare price, that they can be charged with a deceptive trade practice. This can put a pharmacist's license in jeopardy because when a pharmacist renews their license, they are required to let the pharmacy board know if they've had any legal actions against their license. Furthermore, this bill will allow an aggrieved, angry patient the right to sue the pharmacist or the pharmacy. In other words, this bill will make your friendly neighborhood pharmacist a criminal and potentially bankrupt him or her and potentially place their license and practice in jeopardy if they do not sell these drugs at a discounted price, again, a price that is lower than their cost. How many of you would do that? If you were a pharmacist, would you sell a drug for $300 less than you paid for it? And if you didn't do it, you could be charged with a deceptive trade practice? Come on, this is ridiculous. Being charged with a deceptive trade practice or putting themselves or the pharmacy in harm's way of being sued are not good options. Assuming this bill could become law and enact the provisions of this new law, there's not one sentence in this bill that the reduced cost of the insurance be passed on to the consumers. If this bill passes and Medicare is not successful in negotiating a discount with a particular manufacturer, the manufacturer can just pull their drug off the Medicare formulary and the patient will not get it, or unless they want to pay for it. This could cause a patient presently receiving an expensive drug now, covered by Medicare, to having to pay for 100% of its price. AB 250 is a well-intentioned piece of legislation, but it targets the wrong entity. Why target pharmacists or pharmacies that do not control what price they buy the drugs for wholesale for? Unfortunately, if the state passes a law requiring pharmacies to sell prescriptions that honor the discounts given only to Medicare prescription discounts, will not be extended to pharmacists by their wholesalers, the state will have no legal standing to enforce such a law. So what will pharmacists do if this legislation is passed? They will refer you to another pharmacy, who will refer you to yet another pharmacy, et cetera, et cetera. The net result will be that you will have to get your top 10 meds from a out-of-state pharmacy. Pharmacies cannot sustain losing hundreds of dollars for each top 10 drug dispensed, nor can they risk being sued or taint their licenses. This legislation turns out to be what we call feel-good legislation that will likely not yield any discounts given to patients on private insurance plans and give our constituents a false promise, which is really unfair. A better way to help consumers lower their costs of medications and their copays that they will pay will be to regulate the pharmacy benefit managers that rake in billions of dollars in drug rebates and discounts for themselves at the expense of what we could be saving our patients. I can assure you, you'll see such legislation in 2025. But for now, I remain opposed to this legislation. Please don't make your pharmacist a criminal, and don't bankrupt your pharmacist or pharmacies as well. Please vote no on this unthoughtful piece of legislation.
Any further remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 13, the noes are 7. AB 250 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 275, introduced by Assemblywoman Hardy, etc., and Senators Hammond and Smearman, revises provisions governing the sealing of criminal records. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective on July 1, 2023. End of bill.
Senator Krasner.
Thank you, Mr. President. Assembly Bill 275 prohibits a court or agency of criminal justice in this state from charging any fees related to the sealing of a criminal record if at the time the crime for which the record to be sealed was committed, the petitioner was being sex trafficked. The petitioner is required to include a statement in the petition certifying that at the time that the petitioner was being sex trafficked.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 275 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 309, introduced by Assemblywoman Hanson, revises various provisions governing common interest communities and condominium hotels. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. Section 12 and Section 12 and bill.
Senator Wynn.
Thank you, Mr. President. Assembly Bill 309 authorizes the use of secret electronic ballots for the election or removal of members of the Executive Board of a Unit Owners Association of a Common Interest Community and for the election of delegates or representatives to exercise the voting rights of unit owners in such association. The bill provides that a member of the Executive Board who is the subject of the removal may submit a written request for a meeting of the Executive Board at which the removal will be discussed as an agenda item. Notice of such requested meetings must be given to the unit's owner within 5 days after receipt of the request. The bill requires the association to deliver required notice or communications to the electronic mail address that the unit owners designates as set forth on how the association must deliver such notices to an owner who has opted out of receiving electronic notices. The bill also provides that money in the operating account of the association may be withdrawn without the usual required signatures for purposes of making automatic payments for certain costs.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Secretary will close the roll. The yeses are 20, the noes are 0. AB 309 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 334, introduced by Assemblywoman Brown May, revises provisions relating to insurance for motor vehicles. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
I have amendment number 740, proposed by Senator Pizzina.
Senator Pizzina.
Thank you, Mr. President. I move to dispense with the reading of Amendment 740.
If no objections, so ordered. Senator Pizzina.
Thank you, Mr. President. I move to adopt Amendment 740 to AB 334.
You've heard the motion. Senator Pizzina.
Thank you, Mr. President. Amendment 740 increases the time frame in which an insurer must inspect a motor vehicle for potential repair or further examination related to a claim from 6 business days to 8 business days.
Any remarks from the floor? Senator Lang.
Thank you, Mr. President. Assembly Bill 334 provides that if an insurer requires the inspection for repair or further inspection.
We need to vote on the amendment first.
Oh, I thought you called me.
No, well, I'm sorry. I saw your button on. So, okay. So, any remarks on the amendment? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. AB 334 is now ready for final action.
Assembly Bill 334, introduced by Assemblywoman Brown May, revises provisions relating to insurance for motor vehicles. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 and Section 1.
Are there any amendments?
There are none. End of bill.
Senator Lang.
Okay, here we go. Assembly Bill 334 provides that if an insurer requires the inspection for repair or further inspection of a motor vehicle relating to a claim by the insured or the claimant, the insurer must conduct the inspection within 8 business days after receiving the claim and accepting liability. An insurer must transmit the completed repair estimate within 2 business days of the inspection. If the insurer fails to inspect or further inspect the vehicle within the time it is required to do so, or fails to provide the required completed estimate, the insurer waives its rights to inspect or further inspect the vehicle, and with certain exceptions, negotiates for payment of the claim are limited to the cost of labor and price of parts. The measure authorizes the Division of Insurance of the Department of Business and Industry to impose an administrative fine of not more than the actual damages or $1,200, whichever is less for each violation. The effective date on this bill is October 1, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 13, the noes are 7. AB 334 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 342, introduced by Assemblyman Hibbets, etc., requires a cannabis establishment agent to take certain actions to verify the age of a consumer before selling cannabis or a cannabis product. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 2 into Section 2 into bill.
Senator Buck.
Thank you, Mr. President. Assembly Bill 342 requires a cannabis establishment agent to verify the age of a consumer by checking a government-issued identification that contains a photograph of the consumer using an approved scanner to determine the validity of the identification before selling cannabis or a cannabis product to the consumer. The bill is effective upon passage and approval.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 342 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 356, introduced by Assemblywoman Dickman, etc., and Senator Seaver Scancer, etc., enacts provisions relating to mobile tracking devices. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective on July 1, 2023, and a bill.
Senator Hansen.
Thank you, Mr. President. Assembly Bill 356 provides that a person commits the crime of unlawful installation of a mobile tracking device if the person knowingly installs, conceals, or otherwise places a mobile tracking device in or on the motor vehicle of another person without the knowledge and consent of an owner or lessor of the vehicle. A person who commits such a crime is guilty of a misdemeanor for the first offense, a gross misdemeanor for the second offense, or a Category C felony for the third or any subsequent offense. The provisions of the bill do not apply to a law enforcement officer who installs, conceals, or otherwise places a mobile tracking device in or on a motor vehicle in accordance with all applicable requirements of the United States Constitution, the Nevada Constitution, and the laws of this state. This bill is effective on July 1st, 2023.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 356 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 392, introduced by Assemblywoman Kasama, etc., makes various changes relating to property of the people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 9 into Section 9 into bill.
Mr. President,
Senator Cannizzaro.
may we go to order of business number 9?
We are now on order of business 9.
Thank you, Mr. President. I move to take Assembly Bill number 392, place it on the Secretary's desk for the purposes of further discussion.
If there are no objections, so ordered. We're now back on order of business 13. We're on My list says 405, but the screen says, yeah.
Assembly Bill 405, introduced by the Assembly Committee on Judiciary, revises provisions relating to court programs for the treatment of mental illness or intellectual disabilities. People of the State of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 and Section 1.
Are there any amendments?
There are none. Section 7, this act becomes effective on July 1, 2023. End of bill.
Senator Scheibel.
Thank you, Mr. President. Assembly Bill 405 authorizes the Justice Court or Municipal Court to establish a program for the treatment of mental illness or intellectual disabilities and to transfer original jurisdiction of a case involving an eligible defendant to the District Court if the Justice Court or Municipal Court has not established such a program or if the court determines that the transfer to be appropriate and necessary. An eligible defendant includes a person who appears to suffer from mental illness or an intellectual disability, regardless of whether the person has tendered a plea or been found guilty of a misdemeanor offense. The bill further provides that the District Court, Justice Court, or Municipal Court may impose sanctions against the defendant for the violation, but allow the defendant to remain in the program.
Are there any remarks from the floor? Senator Stone, your light is on. Does that mean you want to speak, or is it just on? There you go. Thank you. Are there any remarks from the floor? Seeing none, Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 405 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 408, introduced by Assemblywoman Brown May, revises provisions relating to motor vehicles. People of the State of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 3.9, end of Section 3.9, end of bill.
Senator Harris.
Thank you, Mr. President. Assembly Bill 408 prohibits a person from driving a vehicle in an unauthorized trick driving display or facilitating an unauthorized trick driving display on premises to which the public has access. Additionally, the bill authorizes a law enforcement officer to remove or cause to be removed a vehicle to a place of safekeeping if the person driving or in actual physical control of the vehicle is issued a citation for reckless driving. The operator of a tow car is required to consider charging a lower rate than set forth in the otherwise applicable schedule and reporting certain deviations to the Nevada Transportation Authority in an annual report. Lastly, the bill revises provisions prohibiting the solicitation of a tort victim to employ, hire, or retain any attorney at law in certain circumstances. The bill is effective on October 1, 2023.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 19, the noes are 1. AB 408 has received a constitutional majority, is declared passed, and ordered to the Assembly.
Assembly Bill 423, introduced by the Assembly Committee on Government Affairs, revises provisions governing boards of trustees of school districts. People of the State of Nevada, represented in Senate and Assembly, to enact as follows, Section 1 into Section 1.
Are there any amendments?
There are none. Section 2, this act becomes effective on July 1, 2023. End of bill.
Senator Neal.
Thank you, Mr. President. Assembly Bill 423 prohibits the Board of Trustees of a school district from taking any action at a regular special meeting after 11:59 p.m. on the day of the meeting, except in an emergency that impacts the school district.
Are there any remarks from the floor? Senator Hansen.
Thank you, Mr. President. We had an amendment. There was a floor amendment. It is Senate Amendment number 674, and I would like to ask a question of the senator that proposed the amendment. If my understanding is, by reading this amendment, which has not had an opportunity to go through any hearings, that the intent of the amendment is to deny the right of school boards to block biological males from going into biological female bathrooms, locker rooms, or any sporting events. Is that correct? And that's Section 1 of Senate Bill 423. Am I missing something here? I'd like to get that clarified. The amendment, as I'm reading it, says very clearly that a board of trustees will now be penalized to the tune of $5,000 a day if they do anything that involves sexual orientation, gender identity, or expression, and deny anybody who has that to any use of school facilities or activities.
Well,
Correct or not?
Senator Hansen, I
That is
don't
a
know.
question.
I don't know who you're directing that to, but.
That is to the sponsor of Senate Amendment number 674, which is Senator Donati.
Okay, if that is the case, does Senator Donati want to answer that question?
Thank you, Mr. President. The amendment to Assembly Bill 423, which was amended, specifically states that existing law provides each of the Board of Trustees with the district with certain exceptions, and the amendment says that the providers that a Board of Trustees shall not adopt a policy that limits the access of a pupil because of a race, religious creed, color, national origin, disability, sexual orientation, gender identity or expression, ancestry, familial status, or sex to school facilities or activities. So that's pretty much what the amendment says.
Thank you.
Thank you, Mr. President. Well, I will now address that. And that bill is an extremely controversial amendment, and I could tell several of our colleagues, including members of the majority party, were surprised by what I asked. But what this bill does now, and by the way, the original bill was fully supported in the Assembly, but with this amendment, this is now exceptionally controversial. We have now basically criminalized the school boards of Nevada from dealing with the ability to block biological males from participating in female sports. And since this includes facilities, that would, and I asked LCB, that would include bathrooms, locker rooms, and so forth. So I would absolutely encourage my colleagues to, this, to drop this as a floor amendment without any hearings on what could arguably be one of the most controversial discussions across the entire nation at the moment is a big mistake. So I would urge my colleagues or the Senate Majority Leader, if we want to perhaps reconsider that amendment, I would like to ask for that, but since it's on there already, I would encourage my colleagues to absolutely vote no or postpone this vote till we have an opportunity to discuss the amendment. The original bill was supported by everybody in the other house, and we were all fine until the amendment was dropped as well, I might add. So in the absence of removal of this amendment, I'm interested in making sure that we protect especially female sports from having biological males being allowed to compete in those types of events, and absolutely want to make sure that biological males are not allowed into biological female locker rooms or bathrooms, which this amendment would now prevent a school board from doing, and would not only prevent them, but would authorize a fine of $5,000 a day for every day that those school boards have that policy in place. So I would urge my colleagues to please reconsider this amendment, and in the meantime, in the absence of that reconsideration, to vote no on Assembly Bill 423. Thank you, Mr. President.
Senator Scheibel.
Thank you, Mr. President. I rise in support of AB 423, and I just want to clear up something for the record. This does not impose any new criminal penalties or create any kind of criminal statutes in Nevada law. The amendment that my colleague referenced does, in fact, prohibit the school boards from imposing any kind of policy that discriminates against students based on any number of protected classes, including race, national origin, creed, color, religion, disability, sexual orientation, gender identity, or expression. And the fine that can be imposed is an administrative penalty. That is the standard function, or the standard way that we hold boards and commissions accountable, is through an administrative penalty if they violate this provision. This is intended to protect all students at every school from discrimination in any form or any way, shape, or form. And so that's why the amendment is not targeted at a specific group of students, and it is not intended to marginalize any group of students, but is broadly written to protect every student's right to be free from discrimination within their educational setting. And so I'm happy to support AB 423 and encourage all of my colleagues to do the same.
Senator Hansen.
Mr. President, thank you. Again, this is an extremely controversial subject, And we should absolutely suspend the vote on this until we have an opportunity for both houses, or excuse me, for our house to really get into this. Because while it is true we're not criminalizing it, we are going to definitely be fining school boards $5,000 a day for essentially saying that biological males will not be allowed to participate in biological female sports or go into biological female locker rooms. And I can assure you, I would call this amendment the Bud Light Amendment. I mean, that is a major controversy across this state. There's an enormous backlash across this country on this very issue. And to do this as a floor amendment and not have any hearings and put it on a bill that originally was fine, which both parties supported completely in the other house, is absolutely an abuse of the process. So again, I don't know if we can stop it at this point, but in the absence of stopping it, the people that vote for this bill are basically saying we are going to penalize school boards that try to block biological males from participating in biological female sports. So I would urge you to very carefully consider this vote, because this is a major issue that we should have had extensive discussions on in committee and in our caucus rooms, not on a floor amendment at the last minute in the last waning days of a legislative session. So again, I urge you to vote no, in the meantime, on AB 423. Thank you, Mr. President, for the second bite at the apple.
Senator Harris.
Thank you, Mr. President. I'll be very quick because it's getting late into the night. I just wanted to rise in support of Assembly Bill 423 and just make a quick note that while we have the majority in this legislature, protecting children will never be controversial. That is the choice that we are going to make. And to my colleague here to the left, I would suggest he should be more worried about girls being able to jump into boys' sports, give them a bit of a run for their money. Thank you, Mr. President.
Any further remarks?
Mr. President, can we get a 1-minute recess?
We are on recess. The Senate is back in order. We are on Order of Business 13, General File. We are on AB 423. Are there any further remarks? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 12, the noes are 8. AB 423 has received a constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 432, introduced by Assemblyman Koenig, revises provisions governing optometry. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 into Section 1.
Are there any amendments?
Amendment number 779, proposed by Senator Doñate.
Senator Donate.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
If there are no objections, so ordered. Senator Donate.
Thank you, Mr. President. I move to adopt the amendment.
You've heard the motion, Senator Donate.
Thank you, Mr. President. The amendment removes Section 13 from the bill.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. AB 432 is now ready for final action.
Assembly Bill 432, introduced by Assemblyman Koenig, revises provisions governing optometry. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 30, end of Section 30, end of bill.
Senator Daly.
Thank you, Mr. President. Assembly Bill 432 makes various changes to optometry as follows: defines a comprehensive eye examination, prohibits the issuance of a prescription for a corrective lens, engaging in synchronous or asynchronous optometric telemedicine, and monitoring a patient remotely unless the optometrist has performed a comprehensive exam on the patient in the previous 2-year period, and outlines the parameters of optometric telemedicine. The measure restricts optometric telemedicine to procedures and interactions that meet the standard of care. Clarifies the transfer of ownership of an optometric practice upon the death of an owner, and offers the heirs a 1-year period to sell or dissolve the practice, though during the period a person is not exempt from the requirement to obtain a license to engage in practice of optometry. Provides standards for the supervision of interns and residents who have not yet obtained a license to practice in Nevada. Provides a reduced rate for the initial issuance of a license for veterans, and allows the Nevada State Board of Optometry to issue a citation with a fine not to exceed $1,000 in an additional disciplinary tool.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 20, the noes are 0. AB 432 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 444, introduced by Assemblywoman Bacchus, revises provisions concerning child welfare. The people of the state of Nevada, represented in Senate and Assembly, to enact as follows. Section 1 into Section 1.
Are there any amendments?
Amendment number 730, proposed by Senator Harris.
Senator Harris.
Thank you, Mr. President. Amendment 730 to Assembly Bill 444 does the following. It adds language providing that certain provisions of the bill do not apply if a family member within the third degree of contiguity.
Can you?
I move to dispense with the reading of the amendment.
Thank you, Senator Harris.
I move that we adopt Amendment number 730 to Assembly Bill 444.
You've heard the motion, Senator Harris.
Thank you, Mr. President. Assembly Bill 730, Amendment 730 to Assembly Bill 444 does the following. It adds language providing that certain provisions of the bill do not apply if a family member within the third degree of contiguity is adopting an Indian child. It revises provisions concerning gestational agreements to instead reference a child who was conceived by means of assisted reproduction, and revises provisions in Section 30 to require a court to ask each party at the commencement of an adoption proceeding whether they know or have reason to know that a child is an Indian child, and set forth requirements for a court where there is reason to know the child is an Indian child, but the court does not have sufficient evidence to make such a determination.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Aye. Opposed, nay. Motion carries. AB 444 is now ready for final action.
Assembly Bill 444, introduced by Assemblywoman Bacchus, revises provisions concerning child welfare. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 79, end of Section 79, end of bill.
Senator Wynn.
Assembly Bill 444 establishes various provisions governing proceedings relating to the custody, adoption, or protection of Indian children or the termination of parental rights to provide additional protections for Indian children in state law. The bill requires the court administrator and the Division of Child and Family Services of the Department of Health and Human Services to submit reports to the chairs of the Senate and Assembly Standing Committees on Judiciary containing certain data related to Indian children in dependency proceedings.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. Yeses are 20, the noes are 0. AB 444 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill 465, introduced by Assemblyman Yeager and Gray, revises provisions governing the state militia. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
Amendment number 747, proposed by Senator Spearman.
Senator Spearman.
Thank you, Mr. President. Move to dispense with the reading of the amendment.
There are no objections, so ordered.
Thank you, Mr. President. Move that the Senate adopt amendment number 747 to Assembly Bill 465.
You've heard the motion, Senator Spearman.
Thank you, Mr. President. The amendment does one thing. It adds Senator Spearman as a joint sponsor.
Are there any remarks from the floor? Seeing none, those in favor signify by saying aye. Opposed, nay. Motion carries. AB 465 is now ready for final adoption.
Assembly Bill 465, introduced by Assemblyman Yeager and Gray, revises provisions governing the state militia. The people of the state of Nevada, represented in Senate Assembly, do enact as follows. Section 1, end of Section 1.
Are there any amendments?
There are none. Section 5, this act becomes effective on July 1, 2023, end of bill.
Senator Gokachia.
Thank you, Mr. President. Assembly Bill 465 revises the eligibility for the appointment to the office of Adjutant General or Assistant Adjutant General to require a person to be an officer of the Nevada National Guard, be federally recognized in the grade of colonel or higher, and have completed at least 4 years of service in the Nevada National Guard as a federally recognized officer. The bill also requires the 2 assistant adjutant generals to be selected from the commissioned officers of the Nevada National Guard. Finally, AB 465 provides that enlisted personnel and commissioned officers in the Nevada National Guard serve in accordance with the age requirements set forth under federal law and any applicable regulations. Effective date, July 1, 23, truly makes our National Guard the state militia. Thank you.
Are there any remarks from the floor? Seeing none, the secretary will open the roll. Anyone wish to change their vote? Seeing none, the secretary will close the roll. The yeses are 20, the noes are 0. AB 465 has received the constitutional majority, is declared passed and ordered to the Assembly.
Assembly Bill
Mr. President.
Senator Cannizzaro.
Thank you, Mr. President. May I move for a brief recess to the call of the chair?
We are in recess. good? Senate is back in order. We are on order of business 13. Senator Canizaro.
Thank you, Mr. President. May we go to order business number 9?
We are now on order of business 9.
Thank you, Mr. President. I move to take Assembly Bill 188 from its place on general file and place it on the Secretary's desk for purposes of further discussion.
There are no objections, so ordered. We are now on order of business 13, general file.
Assembly Bill 175, introduced by Assemblyman Yurick and Bilberry Axelrod, revises provisions governing boards of trustees of school districts. The people of the state of Nevada represented in Senate Assembly do enact as follows. Section 1 into Section 1.
Are there any amendments?
I have amendment number 789, proposed by Senator Lang.
Senator Lang.
Thank you, Mr. President. I move to dispense with the reading of the amendment.
There are no objections, so ordered. Senator Lang.
I move to amend Assembly Bill 175 with Amendment 789.
You've heard the motion. Senator Lang.
This amendment does one thing. It says that each trustee of a school district to which the section applies must reside in the election district in which a trustee represents and be elected by the voters in that district.
Are there any remarks from the floor? Seeing none, all those in favor signify by saying aye. Opposed, nay. Motion carries. AB 175 is now ready for final action.
Assembly Bill 175, introduced by Assemblyman Yurick and Bilberry Axelrod, revises provisions governing boards of trustees of school districts. The people of the state of Nevada represented in Senate Assembly do enact as follows. Section 1 into Section 1.
Are there any amendments?
There are none. Section 9, this act becomes effective on July 1, 2023. End of bill.
I have two people standing up. Okay, Senator Lang.
We like each other. Thank you, Mr. President. Assembly Bill 175 adds 4 appointed non-voting members to the Board of Trustees of a county school district with more than 75,000 students, currently Clark County School District. The bill specifies the appointment process and certain roles and responsibilities of these 4 members and further provides for quorum requirements and filling of the vacancy of the board. The bill is effective July 1, 2023.
Are there any remarks from the floor? Seeing none, the Secretary will open the roll. Anyone wish to change their vote? Seeing none, the Secretary will close the roll. The yeses are 16, the noes are 4. AB 175 has received the constitutional majority, is declared passed and ordered to the Assembly.
That concludes order of business 13 on the second agenda.
Order of business 8, waivers and exemptions.
Waiver of joint standing rules, a waiver requested by Senator Canizaro for Assembly Bill number 285 to waive subsection 4 of Joint Standing Rule 14.3 has been granted effective May 26, 2023. Signed Senator Nicole Canizaro, Senate Majority Leader, and Assemblyman Steve Yeager, Speaker of the Assembly, and a waiver.
Order of business 16, remarks from the floor, introduction of guests. Senator Canizaro.
Thank you, Mr. President. First, I want to thank everyone for what is always ends up being a little bit of a late hour, but maybe a little earlier than the very bitter end. And then I just wanted to take a moment to say a huge thank you to all of our staff who were here early and here late and helping to make sure that we can do our jobs to the best of our abilities and keeping us here and able to continue to do the work of the people. We just really appreciate everything. And if you would all join me in a round of applause for our truly amazing staff who do an excellent job every day. And with that, Mr. President, I would move that the Senate stand in adjournment until the hour of 1 p.m. on Saturday, May 27th, 2023.
You've heard the motion. All those in favor signify by saying aye. Opposed, nay. Motion carries. We are adjourned.